When the lawsuit arrived, I thought it had been delivered to the wrong address. No HOA in America could honestly believe it owned my land. Or so I thought. My name is Jake Morrison. My grandfather left me 1,600 acres of ranch land in northern Montana. Our family had owned the property for nearly 70 years. Every boundary was professionally surveyed, every deed was recorded, and every tax bill had been paid on time. The ranch wasn't just land. It was my family's history. About 2 years after I inherited it, a luxury subdivision called Silver Creek Estates was built next to the eastern boundary of my ranch. At first, everything was peaceful. Then Karen Reynolds became the HOA president. Karen believed every piece of land surrounding the neighborhood should serve the HOA. First, she demanded access across my ranch so residents could enjoy nature walks. I politely declined. Next, she insisted I remove my cattle because they ruined the community view. Again, I refused. A few weeks later, expensive HOA signs suddenly appeared inside my property line. They claimed the area was a future community recreation expansion. I removed every sign the same afternoon. That's when the certified letter arrived. The HOA was suing me. According to their complaint, they claimed my family had abandoned portions of the ranch decades ago and that the HOA had gained ownership through continuous public use. I couldn't believe what I was reading. Their entire lawsuit depended on one assumption, that nobody had maintained or occupied the land for many years. Unfortunately for them, my grandfather documented everything. Boxes filled with handwritten journals, old photographs, property maintenance logs, livestock records, survey maps, even receipts for fence repairs dating back 40 years. Every inch of that ranch had a paper trail. My attorney smiled when he saw the evidence. "This case won't be about opinions," he said. "It'll be about documents." Over the next several months, both sides prepared for trial. The HOA spent thousands hiring surveyors, consultants, and expert witnesses. Karen confidently told local reporters the ranch would soon become a community park. She even announced future hiking trails before the judge had heard a single argument. Then trial day finally arrived. The courtroom was packed. Dozens of HOA residents attended, expecting a quick victory. Karen entered wearing a bright smile. She looked absolutely certain she'd already won. The HOA's attorney argued first. He claimed residents had walked across sections of my ranch for years without interference. He argued that old fences had disappeared and that the HOA had invested money maintaining certain trails. Then my attorney stood. Instead of giving a long speech, he placed 3 large storage boxes on the evidence table. Inside were decades of records, photographs showing my grandfather repairing fences, tax records, livestock permits, aerial photographs, property surveys, maintenance contracts. Every document was dated. Every document was authenticated. Then came the witness everyone had forgotten about, 86-year-old Harold Benson. Harold had worked beside my grandfather for nearly 30 years. He calmly explained how they inspected every fence line every season. He described replacing boundary markers, repairing gates, moving cattle, maintaining roads. The HOA attorney tried challenging his memory. Harold smiled, then reached into his pocket. He carried the original ranch maintenance notebook he'd personally written throughout those years. The courtroom became completely silent. Every entry matched the official records. Every date matched the photographs. Every repair matched county permits. Karen's confident expression slowly disappeared. But the biggest surprise came from the county survey office. The judge allowed newly recovered aerial photographs taken over 4 to 5 years earlier. The photographs clearly showed continuous fencing surrounding every disputed acre. Even more damaging, the HOA's own subdivision had accidentally built several decorative entrances a few feet onto my land. Their lawsuit had exposed their own encroachment. Suddenly, the entire case changed direction. Instead of defending my ownership, the HOA now had to explain why its entrance monuments, landscaping, and walking paths crossed onto private property. Karen looked completely stunned. Her attorney quietly requested a recess. When court resumed, settlement discussions began almost immediately. But I wasn't interested. Not anymore. After everything they'd put my family through, I wanted a ruling. 3 days later, the judge issued the decision. The HOA lost every single claim. The court confirmed my ownership of all 1,600 acres. The HOA was ordered to remove every structure built on my property. They were also required to pay my legal fees and restoration costs. The decorative stone entrance, the walking trails, the landscaping, everything had to go. Karen resigned as HOA president before the demolition even began. Several homeowners later apologized, admitting they had trusted Karen without ever checking the facts. Watching construction crews remove those entrance monuments felt strangely satisfying. Not because I enjoyed seeing people lose, but because the truth finally mattered more than assumptions. My grandfather always taught me one lesson: take care of your land, and your land will take care of you. He was right. His careful records, his discipline, and his respect for ownership protected our family decades after he was gone. The HOA believed expensive lawyers and confident speeches would win the day. Instead, one family's history, carefully preserved for generations, changed everything. Because in court, facts will always outlast opinions.